Constitutional originalism is inextricably wedded to history. Ever since the provocative theory of interpretation emerged several decades ago, its core commitment that the United States Constitution should be interpreted today in accordance with its original meaning at the time of its inception has inescapably implicated historical inquiry. To know what the Constitution means, originalists claim, demands that we look to the past. Sometimes that leads inquirers to the more recent past, especially in the case of the enormously important Reconstruction amendments that were added to the Constitution following the end of the Civil War. But more often than not, it requires a deep dive into the distant 18th century past, a return to the American founding, when the Constitution was created. While history has always mattered to American constitutional interpretation, the marked emphasis that originalism places on the past sets it apart. Nowhere else do the study of history and the practice of constitutionalism and law so directly and consequentially collide. Nowhere in contemporary American life is history more relevant or important. Originalism has taken on heightened significance of late. Thanks to the vicissitudes of recent American politics, the United States judiciary is now stacked with self-identified originalists, and for the first time in its history, the Supreme Court boasts an originalist majority. And we have already begun to see how an originalist court is liable to draw on constitutional history to radically remake modern law. Its recent appeal to the standard of history and tradition to decide a slew of landmark cases is only one of the clearest signals. In the coming years, those with the power to determine the content of fundamental American rights, to freely speak and worship, to keep and bear arms, to enjoy equal protection before the law, as well as the powers of the presidency, the legitimacy of the administrative state, and the scope of the national government's power to reform health care, address climate change, and protect voting rights, will increasingly do so by reference to history and what the Constitution purportedly meant at the time of its creation. The growing sway of originalist judges, meanwhile, has coincided with the steady entrenchment of originalism in the legal academy. Each year, the body of originalist scholarship grows, scholarship originalist judges rely on to justify their decisions. Never, therefore, has it been more important to scrutinize originalism's use of history.